I don't know. After hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everybody doing? Happy Wednesday. Got some good ones for you. We start off with Judge DiSanto. Then we got a fun little break in the action. A good little clip from Judge Stevens. It's not a court case, but it's something you'll enjoy. Then we finish it with the woman that's allergic to electricity. She was back for her second hearing in Judge Simpson today. Judge DiSanto, we have the return of Brownlee, I think his name is. He's the guy who was swearing up and down he was in a hotel, but he had a ceiling fan. Then Judge DiSanto called the hotel to see if he was there. So, yeah, that one's a wild one. We do start off with a landlord-tenant from DiSanto today. Another kind of head shaker, scratcher, head shaker. Yeah, anyways, how's everyone doing? Good to see everybody. See Tommy's here. Hi, Heather. We got Stephanie, Leanne. I saw a couple other names. I saw Phil. Saw Jonathan jump in. Robert, welcome, everybody. All right. I'm not going to go back and read because you know what? We want to get to the court, right? All right. Before I hit the play button, though, you already know what to do. Like and subscribe. Do your jump kick backflips. And if you'd like to donate, my link tree is in the description as always. Please and thank you. All right, let's go. Hey, Lolly, Sashina.
We're recalling the matter of Huntington House Apartments versus Natalie Wally, 2302104. And counsel?
Mark Lando on behalf of plaintiff.
Okay. And Ms. Waleed, your name, please.
Natalie Waleed.
Okay, and so counsel, has there been a resolution at all, or what's going on?
Unfortunately, no, Your Honor. The notes that I got from counsel who handled the hearing this morning suggested that it was a little further along than I think anticipated, and we were not able to resolve the matter.
Okay, so I'm showing that there was a conditional dismissal to enter, and so and that conditional dismissal so the conditional dismissal entered, correct, counsel?
Yes.
Okay. And so who filed this motion? Because I'm having a hard time here in this online file. I was finally able to get back in. But how are we back here today?
I requested it, Your Honor.
Miss Waleed had, I'm looking at the ROA online, Your Honor, and Miss Waleed had sent some correspondence that the court recorded as received on December 8th. I have not been privy to that correspondence.
Okay. And so, ma'am, there was a conditional dismissal entered. And so, and you had requested this hearing, and what was the purpose of that hearing, ma'am?
Your Honor, in the court dismissal, per the negotiations that I had with the previous Huntington House representative in the breakout room, the total that was going to be due, to my understanding, was what's listed in the dismissal of $2277 to be paid by December 29th. My understanding was that I made the payments that are listed out in the dismissal, and I assumed that I would be able to pay the December 2023 rent late. The previous representative did not explain to me the language that he used in the court order that said and all additional fees. I corresponded a couple of times, and there's been miscommunication between the representatives, the leasing house, and the owner, the representative legal people like Mr. Landau, Huntington House leasing office, and Huntington House owners. There's been multiple miscommunications. I asked the young lady this morning if I paid all of my payments, which I have, Your Honor, and I've paid those early. If I paid those as agreed by December 29th in 9 days, on December 30th, I would still owe December 2023's rent. Would Huntington House move to evict me because I would still have a balance outstanding? And the young lady this morning said yes, that they would. That was not explained to me when we were in the court. Neither was it explained to me the 2 times since our last court hearing that I sent emails to Mr. Borkin, the previous representative, and to the leasing agent of this apartment complex. I would never have agreed on November 17th to pay $3,900 in 1 month. I just cannot afford that. I would have asked the court on November 17th to make some sort of other arrangements. So that's what I asked for clarification, and nobody from Mr. Landau's representative, the leasing agent, or the owners has gotten back in touch with me. So I felt like I had to get in touch with the court and have an actual formal hearing, because Mr. Borkin said the conditional dismissal is the binding document.
Okay,
And the binding
All right. Biggin, thank you so much for the raid yet again. I very much appreciate it. Welcome, everybody. Please hit that like button on your way in. To catch you up real quick, this just started. This is a landlord-tenant. This woman has an MBA, and she doesn't understand. It's just kind of head-scratching is all. Judge DiSanto kind of puts it in her place, though. It's the case after this, and then the Simpson one that are the main attractions for tonight. This is just, to get our palate a little wet.
Hold on, please. Hold on. So I'm reading the document. Defendant shall pay the following to plaintiff pursuant to the terms in item 3. The amount was $2,277, and that's what was due through November 17th. Okay, it says that right on here. Defendant shall pay the above along with charges under the lease as follows: $500 by November 30th, $1,000 by December 15th, and any remaining balance by December 29th, along with all charges under the lease which accrued through that date. And so, ma'am, those charges are additional rent. So why, unless you negotiated having the rent paid late for December, I'm not sure why you thought that you wouldn't have to pay the rent on time.
No, you're not. Because they wouldn't be on time already by December 28th, Your Honor. The rent is due on December 1st.
Ma'am, this resolution was as to the arrearage amount that was still owing. That
Yes.
didn't address that didn't do anything regarding your current due. So you're telling this court that you wanted to have a hearing because you don't agree with this anymore, because you couldn't pay your December rent on time. Mr. Gopal, I'm gonna have you please join breakout room 2. Is that what you're telling the court, ma'am?
That I did not understand that I would not be able to pay December rent late. No, I didn't understand that.
So, ma'am, how much have you paid?
Your Honor, I have paid according to the agreement, and I've paid early. On November 30th, instead of $500, I paid $750. On December 15th, instead of $500, I paid $750. The remaining balance on the arrearage alone is $700. After those payments, is $77. That is due for me to pay on December 28th. Well, by the 29th, I'll get paid on the 28th, so it'll be a day early.
Hold on, you said you paid $750 on November 30th and $750 on November 15th.
Yes.
December 15th.
Okay.
I'm sorry, December 15th.
December 15th. Well, this shows $500 was due November 30th, so you overpaid that. And then $1,000 was due on December 15th. And you paid $750 because you overpaid on the 30th, correct?
Yes.
Okay, and so you have until December 29th to pay $777, and the plaintiff is stating that you have to pay that plus
11/22.
Okay, and so Mr. Landau, your response, please?
Yes, Your Honor, the conditional dismissal does indicate that by December 29, she must pay the remaining balance, which is $777, along with all charges due under the lease that accrue through that date. The goal with these conditional dismissals is to have the defendant catch up on her arrearage. And this is for all tenants, to catch up on their arrearages, not, under this extended payment plan, not to just catch up on what's owed as of the date of the court hearing, and then still have a lingering arrearage by the end of December that 3 days later is actually going to be 2 months worth of rental arrearage and have to start a brand new case on the rental arrearage in January on what's now going to be 2 months worth of rental arrearage. And that's what I negotiate on all my conditional dismissals. I make it very clear to tenants that they're also going to have to catch up on the December rent. The manner in which I trained Mr. Borkin when he joined our office is to do the same thing. Obviously, I'm not Mr. Borkin. I was not part of the proceeding on November 17 when this was negotiated out. But that is his routine practice. I know that's how he communicates with tenants, except that there can be some misunderstandings that occur. But that is what we insist upon. And if Ms. Waleed wasn't able to do that, Mr. Borkin would have just gone before Your Honor and sought the entry of a judgment, giving her 10 days in which to pay. So instead, we gave her a month and a half to catch up. But that would be including the December rent.
Okay, and so, Ms. Waleed, you have a master's in business, correct?
I do.
Okay, and so one would presume with the master's in business that you understand the language and the principles of making the payments with what would be due, and then how you would still be in arrearage if you were not paying December's rent also.
Well, there it is. We were hoping she got called out for it, not just by us, but yeah, Judge DiSanto called her out too. I mean, I don't understand how you're confused about that. You owe the arrearage plus still have to pay. It's not, they don't put your rent into the arrearage for next month. That's not how that works. She should know that. She really should know that. I think she does, and she's just using this as a way to prolong this. That's my guess. That's just my guess. But you can see Gold Paul just signed in. Gold Paul is our good old friend that's defending Mr. Brownlee, who the jail just came into. Gold Paul's at a pub. He's at some kind of pub, though. He is not in an office. You'll see that a little later.
No, Your Honor. My master's degree is in business and is not in law. But I do know from my master's that the court order is the binding document. And I guess, Your Honor, I just did not understand, and it's not spelled out. Mr. Borkin and I did not discuss December rent at all. And when I looked at the document, when he told me the number of $22.77, that was to catch me up with the arrearage. I understood that. I understand also that I have the lease that's ongoing because I wasn't moving out. And I do understand, and I have paid, and I'm willing to pay the late fees up until we came to court. But I felt like,
ma'am, why Why should your landlord continue to accept payments 1 and 2 months behind?
Because it would be 1 month behind, Your Honor, because we entered into this negotiation. If the landlord, and because I have paid the late fees, and I have shown that I have a willingness to pay this landlord every 2 weeks until it is caught up. And what's at issue here with myself and Mr. Landau is that he says that he doesn't have authority, and he said that he called the owners of the apartment complex just now. He only has the authority to extend out my payments to catch up for 1 month. And I asked Mr. Landau to extend it out for 2 months with payments every 2 weeks, and they are not amenable to that. I feel that because
Ma'am. What is happening now is that now it's snowballing. And so that is why, as Mr. Landau just stated on the record, that the agreement is as it is because it allows you an opportunity to catch up on the arrearage and not get further behind. Because now you're talking about you are catching up on the arrearage, but you're still behind. And now you're wanting an additional 2 more months to catch up on what's going to be due for December and January. So the order was entered. If you'd like to get legal representation, and the court even asked if you understood everything that was going on, you stated yes. And Mr. Borkin had put all those terms on the record. You can certainly file a motion if you'd like.
I can certainly file a motion. I didn't hear the rest of it, Your Honor.
If you would like. But other than that, this conditional dismissal has been entered. And I believe it's been entered. I can't tell on this
It's entered, Your Honor.
screen.
It was entered November 28th.
Because ma'am, at the end of the day, I don't believe that the attorney that was here that day would have agreed to anything else. Maybe he would have, I don't know. But since this would have been on November 17th, before November 17th, I believe it was. And if I would have entered a judgment, ma'am, then you would have had until November 27th to pay your move out. So I'm not, you might want to contact some rental assistance place, ma'am, or some low-cost attorney as well, and see what your options are. But at this point, I don't have a basis to set this aside.
And you don't have the basis because you say that I understood what Mr. Borkin put in the conditional order?
Yeah, it was all put on the record.
Mm-hmm. Well, I didn't understand that, Your Honor. Just as I didn't understand, and I asked in your courtroom what signing one of the check boxes for A, B, C, or something like that meant that they would be able to evict me without even coming back to court. I did not understand that either, and asked for that explanation while we were in the courtroom.
Right, and I gave that explanation. That means that they would submit an accounting along with an affidavit of noncompliance and an order of eviction all at the same time if payment was not made timely on any of those dates. Mr. Landau, we can do one of two things.
Okay.
One of two things. We can set this for January 3rd, and then we can just hold it as a hearing and enter a judgment accordingly if there's a resolution, or we can hold the hearing. That's up to you.
So I didn't understand that, Your Honor. We can hold a motion on the 3rd, or we can hold a hearing on the 3rd?
No, I'm sorry, I directed that to Mr. Landau right now. Just one moment. Mr. Landau?
Oh, yes, Your Honor. When you said just one moment, I thought you were addressing something else. So the options are to hold a hearing on January 3 on, let's
On
call,
your complaint that you filed for possession.
I'm just looking for the court to uphold the conditional dismissal that was agreed to on November 17th.
Well, and again, ma'am, you sent a correspondence in, I believe you sent it via email maybe to my landlord-tenant clerk. This was not a properly filed motion. The court has not heard anything that would be a legal basis to set this consent order for conditional dismissal aside. And so the court's going to proceed accordingly. And so, ma'am, you have until December 29th on your remaining balance there.
All right, Your Honor.
Have a good day. All right, thank you, Mr. Lando.
Thank you, Judge.
All
Have a
right,
good day.
all right, you as well. And we are on the record.
All right, here we go. Bottom left-hand corner, Mr. Brownlee. This is probably why most people came to watch this video tonight, and he does not disappoint. And Glitter, I saw what you said. No spoilers. Don't spoil it. But that was really funny when he says that.
In the matter of the city of Windover, David Brownlee, 232465A and B. And Mr. Goldbaugh? You're muted.
Thank you, Your Honor. John Goldpaw, P30758 on behalf of Mr. Brownlee.
All right, thank you. And Mr. Brownlee, your name for the record, please.
Good afternoon, ma'am. My name is David William Brownlee.
Okay, and so today is the date that we have Mr. Brownlee before the court. The court is going to make a record that on December 12th, defendant zoomed in. Actually, on November 30th, Mr. Brownlee was arraigned. This court issued a $15,000 10% bond. And there was a surety bond posted. And it showed a Zoom ID. So Mr. Brownlee zoomed in from what he claimed was a hotel room at the Wyndham Garden in Romulus. This court advised Mr. Brownlee he was to appear in person. And this court ordered Mr. Brownlee to appear in person. And the court, as of 4:30 p.m., defendant had not appeared. And due to Mr. Brownlee's criminal history as well as his danger to the community, the court issued a warrant immediately. The case had not been called on the record. And counsel?
Yes, Your Honor. In fact, if the court may recall, I was present in court on other matters that afternoon. I've spoken to Mr. Brownlee. I see that a warrant was issued and the bond was set at $25,000, 10%. And he was picked up, I guess, by the Brownstown or some other police department. Your Honor, I've spoken to Mr. Brownlee. He indicates obviously that this was a problem that he created. However, those problems were, and it was not an attempt to affront the court. We're asking that the original bond of 10%, the original bond of $15,000, 10% or the bond be reinstated, and he be allowed to appear at another pretrial. Of course, this would be in person. Is that correct, Mr. Brownlee?
Yes, Your Honor.
All right, well, Mr. Goldpaw, what you may or may not be aware of is Mr. Brownlee has a matter in the 25th District Court to which Judge Clifton had to recuse himself. The court was disqualified because of the named victim, that there was a conflict with the named victim. So that matter got reassigned to this court. So the very next day after December 12th, this court sat at the 25th District Court for Mr. Brownlee's case there. That was in person, never a question as to whether that was a Zoom or not. and he didn't show up for that one either. And so I had to sit for a case in Southgate today, and then Mr. Brownlee appeared on Zoom over there for an arraignment on his matter from the 25th District Court because Mr. Holmberg was already over there as the MIDC attorney. Now, Mr. Brownlee, where was it that you,
Just really quick, I see everyone asking. This is the guy who called in from the motel with the ceiling fan, said he couldn't get a ride. Yes, this is that guy. And I do think it's the same guy that was kind of smirking and smiled at all the women when he was on Zoom court. I think it's that guy too. So I think everyone's right.
were at on December 20th when you zoomed in?
When I zoomed in for court, ma'am, I was at the Wyndham Gardens
Honor,
Hotel
Your
in
Honor,
Romulus, Michigan on Henry
Your
Road.
Honor, Mr. Brownlee, Your Honor, did you say the 20th or did you mean the 12th?
I'm sorry, the 12th, the 12th.
Thank you.
And that was my last day at that motel. After that, I was homeless for 2 days, and then finally I was able to reach out to my family and just beg them for help.
Okay, sir, let me be very clear to you. Let me be very clear. You may think I might be naive, an idiot, I don't know. But I'm very well aware that the Wyndham Garden does not have ceiling fans, nor do they have dark brown ceiling fans, nor do they have anything that is on the walls as such that you had on the walls in your background on that day. So let's be real, and where were you, sir?
I'm being honest with you. I don't know why you're making me or trying to make me think that I want you to think that you're naive or anything along those lines. I think of nothing but respect for you. And I'm being honest. To be completely fair with you today, I honestly wanted just to retract my not guilty plea, have a one-on-one negotiation with you so we can get a global resolution in this case. And then that way, you know what I'm saying, it makes the court's life and my life easier for me to move on and try to become a better person when I get out of jail. Knowing that I have another court case pending that will have restitution enabled. I understand that you don't like sentencing without an updated PSI. Although I wish for you to understand that if you would be willing to just accept my guilty plea for the driving while license suspended, loitering, and for the paraphernalia, I'm not asking anything from you except for just for you to impose your disposition so that we can get this case cleared. Just leaving just the less to go.
Sir, let me be very clear. Perhaps to your surprise, perhaps not, I don't know, but I contacted the Wyndham Garden Hotel because I wanted to confirm if in fact you were there. They would not confirm if you were there or not, but then I went one step further and asked if any of the rooms have ceiling fans. And the lady laughed at me and said, absolutely not. So you were not there. You were not at the Wyndham Garden in Romulus. So where were you? You want this court to believe you for credibility purposes when I'm assessing bond. Where were you?
I was at that building. There's two sets of hotels within the same parking structure. They just bought out the new one. I had gotten a week's stay, and then one over while they're renovating that's half done. That's the one I got, and I got a good rate on it for only $250 a month or $250 a week. I'm telling you, I'm not lying to you. My grandfather
$250 for the week at the Wyndham Garden.
Yes, when normally we were paying $325, and that was the best rate we were getting on Priceline.com. I'm telling you that I'm not lying to you. I have no reason to lie and specify a certain place that I wasn't at. I'm being honest with you. I'm 100 with you. And at the end of the day, like I said, I'm not trying to avert anything more with you. I really honestly wish you could allow me to, accept my guilty plea today so that way we can just get this done and over with. I am clean. I'm not doing any drugs. I want to get my life in order. I want to eventually get out of this situation so I go back to work, try to help the girls pay the property taxes so we can at least get back into the home somehow. I mean, I gotta do something responsible. To me, just accepting guilt and taking accountability today to you, that's the best I could do. Would you be willing to accept that? Because I was driving while my license was suspended knowingly. I did have a chore boy, which was a part of a crack pipe in my person. And I was around somebody who did have drugs on them. And nobody made any promises or threats for me to make this today. This is honestly like the best I can to stand up and be an adult and take accountability for my actions. Please let me.
Mr. Goldbaum?
Yes, Your Honor. If the court wishes to have the plea withdrawn, allow him to enter that plea. I have not discussed this with him. I'm here only for his bond issue, but obviously, at this point, he can, I guess, do what he wishes with respect to that. If the court wishes to, he obviously knows all of his responsibilities. He also knows the consequences, and there's always the possibility that you may send him to jail for those violations. I don't think that I have the ability or even the authority, I'm using that word, to say he can't enter into a plea.
Okay, Mr.
All right, there we go. Gold Paul, this one's done. He's like, hey, I was already off work. You called me. I'm at the pub. I want to do my thing. He says a little bit more about that a little bit later. But yeah, this is where it gets real good. But yeah, he definitely just admitted to everything right there. So even if he didn't change his plea, he just admitted to everything.
You'd
Gold
like
Paul
to enter
let him.
into a plea. On all these matters, you want to enter into a plea of guilty.
Yes, ma'am.
Okay, raise your right hand. You solemnly swear or affirm the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
All right, would you like an opportunity to speak to your attorney further?
No, ma'am.
All right, sir, as to count A, driving while unlicensed, how do you plead?
Guilty, Your Honor.
As to count B, possession of drug paraphernalia, how do you plead?
Guilty as charged, Your Honor.
As to loading or drugs are illegally kept, stored, or used, how do you plead?
Guilty as charged, Your Honor.
And you've gone over your advice of rights with your attorney, correct?
I have.
You understand that you have the right to have a trial in this matter by entering into a plea, you will not have that trial.
I do.
You also understand that you have the right to have this matter set for a pretrial, sir. We don't have to enter into a plea today.
I do.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
That's correct, Your Honor.
And knowing all that, you want to continue with your plea.
Correct. Nobody made me make any threats or promises for me to make this plea. It was 100% willing of my own volitions.
Okay, and there aren't any immigration issues I recall from the last time. And okay, and so you're making this plea knowingly, voluntarily?
Yes, ma'am.
All right. And Mr.
No,
Goldbaum, would you like me to
No,
budget your claim?
I was provided, I didn't mean to cut the court off. I was provided with a registration of action, so I have the registration, so I know the dates.
Okay.
Mr. Brownlee, on 11/30/23, were you driving without a valid driver's license? That was suspended.
I was.
And on the same date and time, were you in the possession of drug paraphernalia?
Yes, sir.
And what was that drug paraphernalia?
It was a screen for a crack cocaine pipe.
Thank you. And were you loitering in a place where drugs were kept?
I was.
And you were aware that those drugs were being kept there, and you nevertheless loitered in that location. Is that correct?
That is correct, sir.
Thank you. Defense satisfied, Your Honor. I'm sorry, Your Honor. And while you were driving without a license, you knew you did not have a driver's license. Is that correct?
That is correct, sir.
Defense is satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea on all counts. And counsel, are you asking for immediate sentencing, or would you like me to schedule this for sentencing?
Well, Your Honor,
I would
guess-
like immediate sentencing, Your Honor.
there you go, Your Honor. He would like immediate sentencing. And the court is obviously aware of the circumstances, having reviewed all these matters.
Okay, what the court is also aware of is that Mr. Brownlee had been sentenced in this court to jail time for his possession the resisting and obstructing an officer matter. It looks as though the possession was dismissed, and he was released from jail. If I recall correctly, it was about 5 to 7 days before this incident on November 30th. Would that be correct, sir?
It is, Your Honor. I'm at your disposal 100% for whatever you feel is fair and fit for me to get to the next step for myself.
Okay, and then Mr. Brownlee is arrested, and again with drug paraphernalia, and with two of the 3 individuals he was with were also with him at the last time that he had his matter with the possession and the resisting and obstructing. And so based upon that recent conviction and jail time, and as well as Mr. Brownlee's criminal history, this court is going to sentence Mr. Brownlee to 93 days jail, which is the maximum that this court can sentence him to.
May I receive the credit from the 30th to the point in time that I had bonded out?
We would be asking for that, Your Honor. Credit for that time served that he's been incarcerated.
You get credit for 6 days, sir.
Yes, ma'am.
And Your Honor, those are 93 days on each matter to run concurrent?
$93 days each count. Court will order that is concurrent.
Thank you very much, Your Honor. May I ask one more question, Your Honor?
Yes, sir.
Is there any way that you would make
I'm sorry, I lost him there, Your Honor.
That wasn't on purpose, but just wait till you hear what question he asked her. He's gonna come right back.
Okay, hold on, he's back through here.
There we go. It's about to go down.
happen on our end?
Okay, I'm sorry, what was that, sir?
Okay, Mike, my question was for you. Is there any way that you'd be able to extend yourself in terms for, would you allow a monetary exchange for the days that I would have to serve? Maybe half, where I would maybe get 45 days reduced if I would be willing to pay $500? Something to that effect?
Absolutely not, sir, we're not bartering. Absolutely not.
Okay,
Absolutely not.
yes, ma'am.
Perhaps you may want to ask for treatment while you're in custody because you weren't even out a week and you have the same type of offense. So no, there's no bartering. There's no money in exchange for not going to jail. No. And in fact, the court's suspending your fines and costs, so you don't even have to worry about that.
I understand. It was just a simple question. I did not mean to disrespect you.
No disrespect, not taken.
Thank you.
So,
Thank you, Your Honor.
all right. Have a good day, off the record.
And Your Honor, as I said earlier today, Merry Christmas, Happy New Year, and I will see you after the first of the year, unless I get another.
Hold on, I thought you're back tomorrow.
No, I'm not there tomorrow, Your Honor.
Well, return our computer mouse, please, before you go anywhere else.
I know, I will make sure that it gets delivered. Sorry about that. I packed two houses.
Okay,
Thank you, Your Honor.
okay.
Right.
All right. All right. Yeah, that was my first thought was bribery. I'm glad I wasn't the only one that thought that. I really thought it was bribery. It's what it sounded like. All right. Before we get into the woman that's allergic to electricity, part 2, I've got a little special Judge Stevens clip for you. All right. It's good. It's good.
This pretty interesting story. This true story. This skunk and this deer and this duck all went to a bar to celebrate the Christmas time season. And at the end of having a raucous evening at the bar, they get the amount due from the waitress. Well, there was a problem. Skunk had not a cent. Deer didn't have a buck. So they all put it on the duck's bill.
You're out of the order, Ron. Did you practice that before coming in?
It's just a Christmas story.
The ultimate dad joke.
Yeah. Grandkids love that story. Didn't get much from this group. Boy.
All right. I know. I got one more. Here we go.
Let me ask you a question. Do you know what a duck's worth?
I have a response to that, sir. Somebody told me a while back, but it's not appropriate for the court, so I can't say it.
Okay. Well, I'll tell you what, it doesn't matter what a duck is worth as long as you can put it on your bill. And if you do that, you never want to run afoul of that payment process. Okay. You're a good sport, kid. All right, what are we doing? Miss Duckworth, let me ask you a question.
All right. That's it for the dad jokes. I promise. Yeah, her name was Miss Duckworth, and her case wasn't all that interesting, but that was kind of judge. So I always find a way to put him in when I can. I've got a good clip of him doing the Jeopardy song, so I'm gonna have to find a way to use that. All right, last clip. What do we got? Oh, the Judge Simpson clip. Duh, I just said that a second ago. All right, let's go.
We're all set. Got it. Let's call the case. Peel versus Gerler. Ms. Gerler, are you there?
I am unmuted, Your Honor. This is Ms. Gerler, and my last 3 digits are 343.
Yes, ma'am. Are we on? This is set for non-jury trial. This was a termination action. Ms. Gerler, what's your defense to the termination? There's a month of.
This is part 2. Part 1 was last week. Part 2 just happened today. So it's not old. It happened today. If you've seen it somewhere else or maybe you saw it, then yeah, maybe it might be old to you. But no, this happened today.
Month lease, correct?
Well, there was a change in agreement as well, Your Honor, and history and backstory that is very much applicable to this situation, I would like to first bring to your attention that I'm a lifelong, long-term renter. Residentially, longest term 13 years, and 8 years. Commercially, I leased an upstairs office at Nichols Arcade from Wilson White Management at that time for 15 years. I have never had a problem paying my bills or until COVID, and which I contracted in fall of 2019, which began a horrendous downhill slide of health, illness, income, and has basically rendered me indigent at age 68. I have tried to get help from agencies, and I have not even heard back from Hawk as to, after my appointment on Monday, as to, how things went. There are many issues beyond what is apparent on the ledger sheet. And when I initially agreed to move into this home, I had another one lined up as indicated previously in our hearing. I requested to stay only 3 months. The plaintiff demanded 6 months because she needed me to watch her home while she and her husband, the landlord, went to Florida for a very long vacation, over 6 weeks, I believe it was, in 2020, beginning of 2022. Problems arose right at the...
Ma'am, can I just stop you one moment?
Absolutely.
All right. This is filed as a termination action. And fundamentally, the issue is going to be because of there is no lease, is going to be, why shouldn't you move?
Your Honor, I've been before you previously, and I have 3 functional disabilities, electrohypersensitivity, which makes me incompatible with any of the wireless utility meters, internet, Wi-Fi, cell towers, etc. This home has also been mitigated for me with the acknowledgement and cooperation of the landlords who, years prior to my tenancy, had replaced the utility meters with opt-out meters when I...
She's not in court. She's calling in over the phone. The landlord's there. The landlord's on the table to the right. I'm guessing it's just a random defense attorney on the left. I don't know who that is. She never says anything. But the landlord's on the right. But this woman's calling in on the phone.
Made them aware of all the issues of electromagnetic frequencies. They have Ethernet installed, and we had things mitigated to reduce the interference of electricity and wireless devices, including Stetzer filters in the plugs of electrical plugs of the home, which was also by verbal agreement. My loan to them on their above floors for the use of the landline digital cable phone, and that which has been denied to me and does not allow me to send more information to the court. My impression from the papers that I was given, and as I indicated in the prior hearing, Judge Barr had said other ones needed to be entered that
I said
apparently
that
were not
during part 1.
Needed. This is collection and termination. Had I had my phone line not turned off to me after I faxed in the confidential contact information requested by the court, I would have been able to send to you a letter from Ms. Peel that she wrote to the Department of Health and Human Services when I applied 3 years ago in 2020, stating that, you know, I was in dire financial circumstances and having problems paying rent with the prior landlord. I did not know at that time I had long COVID. It was also the plaintiff who did the research and informed me in late spring of 2022. But they have awareness of all my frailties and vulnerabilities, which they have not been honoring in any degree, and knowing how very difficult it is for me to find a safe place to live, and I'm going to have to move rurally. There is no housing, affordable senior housing, et cetera, I can be in because of everybody else's need for wireless devices, which are beyond hazardous to me. I suffer from post-traumatic stress disorder from a car accident where when I requested aspirin, they wouldn't give it to me, but narcotics and opiates that were not compatible with me, and a closed head injury that was not diagnosed for a year and a half. So I have 3 strikes against me just as a person functioning in the world with the long COVID, the electrohypersensitivity, and the PTSD. I have been subject to some very harsh, intrusive, invasive treatment as a tenant here for some time prior to these recent occurrences. And the assumption that one has of autonomy, privacy, and enjoyment of property when renting a property have also been denied me.
Okay,
I
Ms.
live
Gerler,
as
Ms. Gerler,
Yeah.
I'm going to stop you for a moment, okay?
Sure.
Those aren't a basis for me not to grant a judgment to the plaintiff. Or at least possession. The issues that you're talking about may relate to their monetary claim. But as to the issue of possession, why shouldn't the landlord get their property back? Let me try to put it that way.
Your Honor, I was under the impression that Hawk and other agencies would be assisting me with the back rent so that I would have time to find a suitable place, because I will literally be on the street with my possessions. I would say that would be today's equivalent of delivering a head on a plate. I have nowhere to go. I have no vehicle. I live as a virtual shut-in with restrictions.
Okay, I understand that. Your name, ma'am?
Pamela Pia.
Okay. Ms. Pio, you've heard all those circumstances. You're aware with this defendant. How much time would you give her to vacate the premise?
Your Honor, I have asked her to pay up or move out since June of 2022. I am a very kind-hearted person. I was aware of the circumstance. However, this whole thing, I'm in my 70s. I depend on my rent for paying my bills. And I kept asking her, hoping, praying that she would leave. And she was unable to do so. And I can no longer carry her on my back.
All right.
Literally, it's.
I hear you, and I understand because of the pretrials in this case, where this case was. So how much is owing?
The the amount of rent owing is $11,995. That's about.
Okay, right. Right. So the problem for both of you is even if, Ms. Gerler, and just listen to me, even if Hawk were to assist you, given what their maximum amounts that they would be able to assist, you'd still have to come up with $9,000. Okay? So there's part of that's the big issue. So when
Your
we
Honor,
get to that,
pardon me.
pardon?
I would just need to inquire about those figures because when I spoke with Autumn on Monday, she said that they had, I believe, a maximum of $5,000 they can issue. She was going to reach out again to Faith in Action for me, whose monies Ms. Peel, the plaintiff, declined in July of 2022, and at that time, other affiliated agencies would have brought me current there was $2,985 owing, but because the plaintiff refused the offers of money, that other monies were not forthcoming. And the plaintiff also knows I have been sequentially ill on a regular basis. There's no soundproofing between the downstairs, upstairs. They hear me hack, cough, sneeze.
Ma'am?
So
Ma'am,
I'm letting you
Ms.
know
Gerler,
it is illness,
Miss-
chronic illness. Yes.
Ms. Gerler. Whether it's 5,000, 3,000, we can get into that argument, but you'd still have to come up with the other 7,000 if it's 5,000. I mean, the problem is that those other amounts are going to be your difficulty.
Your Honor, I don't believe that I should be culpable and responsible for the monies they declined in July 2022, the $2,985, which would knock the equivalent of $3,000 off of the total. When I spoke to Autumn, she said that she would also pursue with Faith in Action. I was denied by Department of Health and Human Services for reasons I don't know, because my mail is being held and I have not gotten that back to me. When you're only making $1,100 a month on Social Security, I don't know why I was denied, Your Honor. I can no longer work. I was self-employed.
I understand that, Ms. Gerler. Ms. Gerler, I understand all of that. But when we all boil it down, the reality is the funds aren't there. And so if the funds aren't there, what's really going to end up happening is you're going to have to move. As I see it, and I'm looking at the case, it isn't a matter of whether or not you will have to, it's a matter of when.
And I would ask that the landlords, knowing my circumstances and situation, please grant some lenience in this case, as they may be leaving at the end of the month to go on a 2-month Florida vacation. I have tried even to get people to help me pack, and people are not available due to our upcoming holiday. I am at this point.
Okay, Ms. Gerler, let me ask you this.
I'm weak.
Ms. Gerler, in your mind, how much time do you need to move?
To be very
Not
realistic.
saying I'm going to give you that much time. How much time? When could you be out?
To be realistic, sir, requiring the assistance and the fact that I may move very far away, I would likely need till the end of January, because I have quite a bit of things to take with me.
Okay, so you need to the end of January.
Yes.
Ms. Field, would you give her to the end of January?
Consult with my husband for 1 minute.
You look like the brain trust, but yeah, go ahead. You can talk.
All right. This doesn't last very long. It's only about 20-second break. Yeah, I don't buy this disease either. It's the Better Call Saul season 1 plot. But still, it's not her landlord's problem. She still needs to pay the
Be
rent.
willing to do January 15th.
Okay. So you won't do
Your Honor,
January.
that's not possible. I apologize for interrupting. It's not possible, sir. Yeah.
Ms. Gerler, hold on.
Yeah.
All right, while he's doing this paperwork thing, there's only about 2 minutes left of this video. So I am going to let it play out. If you haven't done it already, please like and subscribe.
Anybody
Huge
have
up the
anything
subscribe
else to say? Before I give you
And
my
yeah,
ruling.
I
Your
wouldn't give
Honor,
her the
if
option
there
to
was
speak.
anything else beyond hold on, I did not hear it. This is.
No, okay. I was just asking if anybody else wanted to say anything else before I issue my ruling.
Your Honor, I would like to say, if it is possible, they hold $995 in as a security deposit, with which they could keep for the month of January if I were allowed to stay. And of course, we'll continue to look for additional help, but to pay. But they know my circumstances, and
Yes, they do, Ms. Gerler. So here's what I'm gonna do. I don't think that there's really much distinction between the 15th and the 31st, and given your circumstances, Ms. Gerler, I'm gonna grant a judgment to the plaintiff for possession. The writ will not issue till January 31st, 2024. There is
Thank you
an
so
issue
much.
regarding, you're welcome, but there is an issue regarding monies that would be owed. And so a trial on any additional monies that will be owed will be set for March 5th, 2024 at 9 a.m. in person. That will give time. The reason I'm setting it out to that date, that will give time by the time she vacates the premises to then you can do the inspection and you can have all of the damages that we can figure out and hopefully have it told. All right. Any questions from
Your
either?
Honor, the only comment that I have to say, and I'm very sorry, but I cannot appear in person. I can only appear via remote Zoom.
All right.
Due to my disability.
I understand that, ma'am. All right. Yes, ma'am.
Your Honor, you have struggled getting into for many months now. Since I asked her to leave, pay up or leave from the possession that I filed a few months ago, October. The tenant has not paid us any rent, and she will not let us have access to our mechanical room, which unfortunately is, we have to have access to the mechanical room through her apartment. And we give her notices, and then we have people come and she will not, oftentimes won't answer the door, or will just say, you know, whatever excuse, and then we have to continually deal with it. That's why I really didn't want to extend the time, but I understand your perspective. it's been very difficult dealing with her. And
This is not great.
looking forward to this being completed. And I just want to, we do want access to our.
All right, under paragraph 10, when you fill out. Yes, Ms. Gerler.
I would like to respond to that, please.
Which part?
The part about them wanting access to their mechanical room, or access to the apartment. I have been subjected to an increasing amount of hostile, threatening, aggressive action, pounding
Okay,
on
Ms.
the door.
Ms. Gerler, Ms.
And
Gerler.
I would allow them in to do whatever they need to do, but not by myself, with someone else. I have not resisted them. I have been literally ill when they wanted to come
Okay, so
in.
here's, Ms. Gerler, here's what I'm gonna do. On the judgment form, when you fill that out at the counter, under paragraph 10, the defendant is to allow plaintiff access to the mechanical room upon 48 hours notice. Ms. Gerler, that will give you time to get somebody there. That's adequate notice that you, if you're gonna have somebody else go in and look, you got the time to do it.
Your Honor, that is totally fair, and I
Thank
am
you.
thankful.
That's what I do.
I'm very impressed with you, Your Honor, so thank you.
Well, thank you, Ms. Gerler. I appreciate that.
Will you put that in writing or do I need to?
You need to write that under paragraph 10 on the judgment form when you pick one up the front.
Okay. And what exactly do I have to say again?
Defendant, you know what? Go fill out the judgment form. I'll put it under paragraph 10. I got it. Okay.
I actually have it filled out, but this, it wasn't just for possession. This was.
There's a money portion of it too. It's, you wanted possession and you want a money judgment, or
So I can give you both of those.
you can give me the judgment form. The money judgment piece I've adjourned to March.
Okay, so then I don't fill out the money piece. All the rest is.
Do you have the,
I have a form. I didn't expect it.
okay, put the names on there. I'll fill the rest out.
Okay.
All right.